Commit to Wealth Nation. Welcome to the Commit to Wealth podcast. I'm your host, Juan Vargas. Today on the show, we have Arina Shulga. Arina is the founder of Ross Shulga PLLC. She is a corporate and securities attorney with significant experience with advising small to mid-sized companies on formation, contract review and negotiation, private placement of securities, intellectual property matters, and internal governance issues. She has represented a wide range of clients from individuals to Fortune 500 companies. Arina, it's a pleasure to have you here on the show.
Thank you so much.
Yeah, Arina, so let's go ahead and get this thing started. Tell us a little bit about your background. You obviously have a ton of experience in a wide range of law. So tell us, a little bit about what you do, and then we'll kind of focus on the show and private placements. So yeah, go ahead.
Mm-hmm. Great. So I am a corporate and securities attorney. So I work mostly with businesses, with entrepreneurs, with founders of businesses, and I advise them on a whole range of issues, as you just noted. Sometimes I start with company formation, and then we go from through different rounds of fundraising. Sometimes it would be convertible notes, seed rounds, Series A rounds. So I do a lot of private placements. I draft all documents that are required to do the private placements. And I also represent investors, and I also form funds, private equity funds, real estate funds, venture capital funds. So I'm familiar with that space as well.
Okay, so yeah, it definitely is a big range of experience that you have there. So the primary focus on our podcast is private equity. Private equity. There's a lot of individual investors that are doing their own deals. There's passive investors, and there are syndicators. So we have a wide range of audience in this on this podcast. So let's go ahead and talk about the private placements. Okay, so we'll kind of go into that. Tell us, first of all, your experience. What is the average size of the private placements that you're doing? On average, do you have that from the top of your mind?
Yeah, so I would say, I would give you a range. I would say maybe from 1 million to 30 million. That's what, that's, I think, our sweet spot is. So definitely smaller deals. But again, they range in size, but definitely kind of on the smaller side. So I would say.
Okay. So yeah, this is actually a good for anybody out there listening to, if you're actually getting started, then this, you could definitely reach out to her, and, she would definitely be able to help you out with that. So, but let's backtrack a little bit. I just want to know that, from the top of my mind, but let's backtrack a little bit and, tell us what investors should know about securities laws. And first of all, what is security, so that they know exactly what it is.
Okay. So basically, the question is, why should you care? Why should someone who is investing into real estate or who is putting together syndication really care about securities laws? And the reason is many, if not most, real estate deals involve an offering of securities. And if the offering of securities is involved, then you need to comply with applicable federal and state securities laws. So that's kind of the main issue here. So then the question is, so what are the laws? So this is the Securities Act of 1933, Securities Exchange Act of 1934, and then each state has their own version of securities laws, right? Altogether, they're called blue sky laws. I don't know exactly why they're called blue sky laws. It's coming from a case where a judge referred to this opportunity or promise of unrealistic profits, something to do with blue sky. So now we refer to state securities laws as blue sky laws. And basically, if you identify that what you're offering is a security, you have two choices, and this is kind of the general rule, right? You either have to register your offering with the Securities and Exchange Commission, or comply with an available exemption from registration. So either register or find an exemption and conduct your entire offering pursuant to that exemption. So you also asked me, what is a security? Mm-hmm. And again, so the general rule, right, applies, that says that the sale of securities has to be either registered or done pursuant to an exemption, only applies to the sale of securities, right? So mm-hmm. if you're selling not a security, you don't have to worry about it. So then the key issue becomes, what is a security?
Right.
So, so both acts that I just mentioned, the Securities Act, Securities Exchange Act, have those like really long definitions of what is a security. And they even end with saying, in general, any instrument commonly known as a security, that's also security. I was like, okay, wonderful, but that's not really helpful. What is helpful is a 1946 case from 1946. It's called the Howey case, right? That's what defined what is an investment contract. And essentially that case, back in 1946, told us that sometimes a contract that you sign with another party can also become a security. So let me tell you about that case a little, because I think it's very relevant to obviously real estate, and you'll see exactly why.
Yeah, sure.
So Howey had a company, Howey in the Hills Service, right? And both, the company and himself, they lived in Florida. And Howey owned a lot of land with orange groves. And Howey kept, he also had a hotel, right, on that in the same premises. Mm-hmm. So Howey kept some of the land for himself, and then he broke the remainder of the land into small parcels and sold that land to investors. Actually, those people who were staying at the hotel, and then he leased back the land. But that lease back included a service contract, essentially saying that, look, we're going to take care of the orange groves, we are going to grow the trees, we're going to collect the harvest it, sell it, and we're going to distribute the profits to you guys. Okay? So the service contract gave Howey in the Hills full and complete possession of that land and the trees. So they made all the decisions. And the owners couldn't really even access the land during that, the service agreement. And even though they didn't have to enter into the service agreement with that particular company, but Howey really advertised it and said that that would be, the best type of service they could get. So the investors, they weren't professional real estate investors. They were professionals, many of them were doctors, but they really didn't have much to do with real estate or any expertise in that field. Mm-hmm. So when the case went up to the Supreme Court actually said, look, you weren't selling real estate interest. You were selling securities. You were offering securities. And they developed a test. Basically, there are 4 prongs. And if you go and if you meet all 4, then what you have on your hands is a security. And therefore, you have to comply with the securities laws. So here's the test. Okay. So if it is the investment of money or some other consideration, but let's say investment of money in a common enterprise with an expectation of profits derived solely from the efforts of another third party, the promoter, somebody else, then what you have is a security. So, so let's say an investor invests money into a common enterprise. That means there are probably other investors, right? And investors' hope of getting a profit is tied to the promoter's interest in doing well. Then the promoter will get more and the investor will get more. So there is this common enterprise with an expectation of profit. And here I just have to say what that is. So a profit can be either capital appreciation, right? So something, real estate goes up in value, let's say, or it can be like periodic payments, let's say dividends. Even if it's a fixed return, okay, it will still be considered a profit, and that you're going to have the expectation of getting it, right? So, but the investor is actually a passive investor. Investor does not do anything, right? It's the Highway in the Hills Service Inc. that provided like all the, all the work in connection with the trees, right?
Right.
So this passive investor invests the money and hopes to get a profit, but it's going to be derived from the efforts of somebody else, a promoter, a service company, whatever other party. So if that's the arrangement that you guys have, then you just issued securities and conducted a securities offering, and therefore it has to be, either registered or you need to comply with an exemption. So, and this, so this test, investment, the Howey test, that's everybody refers to it as the Howey test, has been applied to many, many different scenarios. So not just real estate interests, but even to the sale of beavers. Can you believe it? The animals, beavers.
Beavers?
And yeah, and also to the sale of pairs of mating chinchillas. Because you see, it's like it doesn't really matter. And also to the whiskey warehouse receipts, it's been all over applied, right? Because it doesn't really matter whether what you invest in is like, citrus groves or the chinchillas. What matters is that you are investing money, and then you're expecting to get a profit from it. But the profit is going to come from the efforts of another party. Right. Yes, somebody else. And that's what really, So, and then people started asking, so what about LLCs, right? Do LLC interests, are they considered to be securities? Because I understand and I know that a lot of real estate investments are done through limited liability companies, right? Now the question is, does the LLC interest, membership interest, is that a security? Well, and my answer to that is it depends, right? It depends on how the operating agreement for that LLC is structured. So LLCs are very nice kind of entities, right? They help you avoid double taxation. They have minimum corporate formalities. They allow you to pass through the losses and income, right, to the members for tax purposes. And also LLC members, they can either be entirely passive or they can assume an active management role, right? And in each case, they're going to maintain their limited liability protection. So here we need to apply the same Howey test. So if the LLC agreement vests managerial authority in the board of managers, then the LLC interests are likely to be securities, right? Because those members are kind of passive. They're not really making any decisions, right, with respect to the role of the LLC. But on the other hand, when the managerial power is spread over all members, everybody's voting and making decisions and actively involved in the life of the LLC and the management, then it can be argued that those LLC interests are not securities, and therefore the securities laws do not apply. Also, so like you see, so it all depends on how the LLCs are structured. Also, the same Howey test has been applied to property interests when they are combined with service contracts. Just like what happened in the Howey case, right? There was a service contract. Well, so here we have, for example, offer and sale of condominium units, let's say in the real estate development, that's coupled with the arrangement for the promoter to perform certain rental services, right? So that could be a security. That could be a sale, offer and sale of a security. Also, if one offers participation in a rental pool arrangement, that could also be a security. Also, if there's this offering of rental sort of like arrangement where the purchaser must hold this unit available for rent for any like certain like long period of the year, right? And must use services of an exclusive rental agent, and is otherwise kind of restricted from occupying the unit. So that's also a security. So you really just need to be careful and evaluate what it is that you're offering exactly. And then apply the Howey test every time you think about it, right? So that's kind of my short, not so short answer
No,
to
it's
your.
good. It was very, very good. So just to recap, if somebody out there is looking to do a deal, they should apply that Howey test, and if it meets one of those four, or it has to meet all of those four, right? So if it meets all those
It
four,
has to be all four.
right? Yeah. So it
That,
meets all four, then it's for sure security, and that's when you definitely should engage a securities attorney to draft a PPM and go that route, because if not, then you can definitely get in trouble. So again,
exactly. Actually, I would say engage a securities lawyer even before to help you do the test. Sometimes it's very obvious, right? Other times it's less obvious, it's more nuanced. But there have been so many cases about this. There have been so many SEC no action letters about it that I think an experienced attorney should be able to tell you pretty much whether in your situation you're doing a securities offering or you're not.
okay, got it. And then somebody can make their decision on which way they're going to proceed, based on what you give them, the input that you give them. That makes sense. Okay,
Yeah.
so we have Regulation D. Okay, so can you talk about Regulation D? That's going to be the most common that we use for real estate, right? Regulation D. We have under that we have 506B, 506C. Can you talk about those a little bit more in detail as well?
Okay, can I first just talk about just a regular private placement? Because there is another exemption that people are not relying on as much, but I just want
Yeah, sure.
your viewers to be aware that it's
For
out
sure.
there. So it's Section 4A2 of the Securities Act, private placement.
Okay.
That's it. So basically this clause in the Act, 4A2 of the Securities Act, exempts any transaction by an issuer not involving a public offering. So that's it. That's the entire guidance that we have from the statute. So basically, this is a private placement, right? So it was like really unclear for people what that entailed. So in 1953, the Supreme Court delivered this opinion in the case of the SEC versus Ross and Arina, where they kind of looked at this private placement to determine exactly what are the parameters, when can you use that. And basically, pursuant to that private placement exemption, you can raise an unlimited amount of money, but from a limited number of investors. So I'm talking about maybe less than 20, right? Maybe 15, but there is no precise number that I can give you, but it's a limited number. Okay. So investors don't have to be accredited, but they have to be financially sophisticated. Okay. And then you cannot conduct solicitation or advertising. And you also have to really provide information about the offering, about the company, also have to provide opportunity to ask questions, of the officers and directors. Investors, they have to have investment intent. So it means that they're not buying just with a hope of reselling quickly, at a profit, or, for profit. They're really holding it. So, for example, the ideal case is if a company is offering some stock to its employees, or maybe a very close-knit group of friends and family. So that's your private placement, okay? And Rule 506B of Regulation D was actually invented as a safe harbor for this particular private placement.
Okay.
So, 506B said, well, essentially the whole point is that if you follow this set of rules, it means that you've complied with the requirements of a private placement, conducting a private placement. It's a non-exclusive safe harbor 5 or 6B. So let's talk about 5 or 6B now that I've mentioned for two private placement.
Sure.
Let's talk about Regulation D. So the two most commonly used rules are 5 or 6B and 5 or 6C, right? And I'll tell you the difference. So let's first do 5 or 6B. So here again, you can raise unlimited amount from an unlimited number of investors, okay? All of the investors have to be accredited investors, except up to 35 investors can be non-accredited, but they have to be financially sophisticated. Maybe not alone, but with a representative. So what I do in these offerings, if there are non-accredited investors involved, it's hard to know exactly how sophisticated that person is. There's no like bright line test that tells me, okay, this person is and that person isn't sophisticated. So I, just to be comfortable, I ask them all to find a representative who is either an attorney or maybe a financial advisor, investment advisor, who would be able to explain, understand first, and then explain to them the risks of the investment. So, and then they sign a little certification. So then it's kind of, it's better. This way I know for sure that these people will be properly looked after, and advised. Okay, so you don't actually, the rule doesn't require you to produce any particular kind of disclosure unless you are offering to the non-accredited investors. So if you have any non-accredited in your deal, you have to produce a PPM. And the rule is actually pretty specific as to what type of information should be included in that disclosure statement. But if you don't have any non-accredited, then no problem. You don't have to, like the rule, I mean, you should, and let's talk about this separately, but you don't have to, according to the rule, produce any disclosure information to the investor.
Why is that? Why is it if you have nothing but accredited investors in your 506B offering, why is it that you are allowed not to have a PPM?
Well, I guess the thinking is that they are definitely financially sophisticated. They should be able to judge for themselves whether or not this investment is a good idea. So they don't need any additional kind of help or information. I don't know. It's just that the rule doesn't require it. Well, but let's talk about it. Let's talk about the PPM and whether or not it's a good idea to not have it. So basically, the private placement memorandum contains all the information that you want investors to know about before they're making their investment decision, right? You get to control that information. And basically what PPM says is that you can rely on the information in this memorandum, but do not rely on any other information, because there can be like news reports, analysts reports, maybe some rumors on the internet. I don't know what else is there. So you want your investor to be only deciding based on the information in the PPM. And then you as the issuer or the promoter of the offering, right? You then make sure that whatever is in that document is accurate, is complete, that you're giving them a complete picture. You know why? Because then you are actually responsible for any material misstatements or omissions in that document. So you need to make sure that it's accurate and it's complete and it gives like the full picture, so to say. Some of my clients, they think of a PPM as a marketing document. It is not a marketing document. It is a disclosure document. Yes, it talks about the benefits of the investment, right? But it also talks about the risks. It has a huge section that's called risk factors, right? That hopefully investors will read prior to making the investment decision. It spells out the terms, all the terms of the offering. And it also talks about, the investment opportunity, what it is that this, the fund will be investing into, what type of property, where, just give all the statistics, the backgrounds, the area, the industry around it, jobs, just the whole picture, so that when the investor invests, they know exactly what they're getting themselves into. Also, the experience of the management team and whoever is running the deal, the promoter and the management company, is very important as well, and should be included in the PPM. So
in a nutshell, it's always the best idea to have a PPM no matter what. Just go with the PPM and be safe, and you're going to be fine.
Yes, especially I think in real estate deals, I rarely see a deal that does not have a PPM. Okay, that's probably a small deal.
Yeah, I've never seen one.
With the same group of investors, that they don't need the PPM, but most of the deals, they do have a PPM. In most cases, it's pretty detailed, and I think that's great, because this is the information that investors should rely on, and that kind of limits the universe of information that is legit. Other information out there, they should not.
For sure. So in a 506B, for your non-accredited investors, your sophisticated investors, right? So you have to have a pre-existing relationship with them, right? So
no, wait. So it's actually Rule 506B, private placement, does not allow any general solicitation or advertising. Right. So let me tell you what that means exactly. So essentially, you're asking yourselves two questions. Is this communication, whatever the communication can be, a statement, it can be an article, it can be a post in the social media, like whatever, is that communication reasonably considered to be a solicitation or general advertisement? If the answer to the first question is yes, then ask the second question. Is it being done in connection with the company raising capital? If the answer to the second question is yes, then you've probably violated the ban on general solicitation advertising that's imposed by Rule 506B. But you can avoid it, okay? You can actually reach out to investors with whom you have pre-existing relationship. Okay, so you are actually looking for pre-existing substantive relationship. Okay, so that type of relationship that would allow the issuer, the company, or its agents to evaluate the substance and duration, the substance and duration of which would allow the issuer to evaluate the financial sophistication of the investor. How sophisticated is that person? Is that person accredited? Does the person even understand what's going on? Right? So here we don't care about the number of investors that is being solicited. So what is pre-existing? Let's define that. Yes. So this relationship has to exist prior to the commencement of the offering. But it's not clear how far in advance it should, originate. There is no so-called waiting period. It's not 30 days, it's not 6 months. There is no exact time, right? It just has to pre-exist, exist before the commencement of the offering. Okay, then you would ask, so what is substantive relationship? Well, as I just said, it's a relationship that allows the issuer to determine or evaluate the sophistication of the investor. What does it entirely mean? Well, maybe the investor will fill out some questionnaires, generic questionnaires. Maybe then the representatives of the company, of the promoter, will talk, engage in conversations, and so on. Kind of just to be able to judge for themselves the financial sophistication of that particular person. You can also piggyback on the pre-existing relationships with the companies like broker-dealer, investment advisor, sometimes attorneys, right? Also, remember that if you're reaching out to investors who've participated in your deals before, that would not be general solicitation advertising. So you can do that.
Right, right. So going back to what you said, the pre-existing relationship and the amount of time that you have to, I guess, know somebody.
Mm-hmm.
So technically, if I meet somebody, say today, right? I don't have a deal today, but I
Okay.
meet somebody today and we just go for coffee and we have coffee and we're talking about their situation and their plans and so there's a relationship that started there
Yeah.
and nothing has been brought to their attention about a specific deal at that moment.
Mm-hmm.
But let's say tomorrow I have an opportunity and he actually happens to reach out to me tomorrow. He's like, hey, do we talked yesterday, but do you have an opportunity? I mean, when do you think you'll have one? And I tell him, hey, I actually came across one today. I can send you the details on it. Once we have the information ready. Is that okay? Something that short and that quickly. Is that okay?
Well, it all depends on particular facts and circumstances, right? There is no clear-cut rules. Like the guidance I give you, that's pretty much all there is, right? Uh, so it depends on the type of the conversation you had. Did this person fill out any questionnaires, maybe kind of disclosing their financial condition? Do you know that person's background? Does he have a PhD in finance, for example? Do you have enough information? Is one meeting enough to get all that information? So it depends, right? It
It still
depends.
depends. Yeah.
But essentially, just has to be done before established, that relationship has to be established before you offer any deals. So that's kind of key for pre-existing.
Okay, that makes sense. Okay. Yeah, so
Also,
you gotta have something going on before you even try to offer anything. You got to make sure you have something going on and try to document it as much as you can, to cover yourself as well, right?
yes, exactly. And also, two other things I wanted to mention. Sometimes companies, like promoters, they issue press releases or newsletters, right? And they're general nature. They don't mention any particular deal, right? And that's fine to do so long as they contain kind of business factual information that is not designed to condition the market or arouse the interest of the investors. So as long as the company is doing it periodically, then even if there is a deal going on, just continue doing it the way you are doing it, and that is not general solicitation advertising. However, if your material, so the information that you put out becomes kind of very rosy, very kind of optimistic, then the SEC can view that as general solicitation advertising if that comes out at the time of the offering. So we need to be just careful about projections in those documents and also kind of keeping them very factual. So that's one thing. And
Okay.
also sometimes people ask me, so if you kind of present to a group of angel investors, let's say you go to an angel group and you present your opportunity, or you go to a group that has, I don't know, interested investors, they organize themselves into a little group where they share different deal flow and stuff. Is that solicitation and advertising? And the SEC, actually, Securities and Exchange Commission, they did talk about this, and they said that if this group is small, tight-knit, and it's kind of expected that different investors would bring in different companies or introduce different deals to the members of the group. So then making offers of securities to these individuals would not actually constitute general solicitation, so or advertising. So you would be relying on the assumption that all of the investors in this group already have the necessary financial sophistication and experience, right? Because that's what they do. They get together and they choose different investments.
Okay.
So that would be okay. But then, if the group starts to grow in size, the bigger is the group, then you start wondering. Or if like you go to the General Assembly, that in New York City it has like over 1,000 members. and they have this huge meetups with like 1,000 people in one room, and you start talking there about your investment opportunity, then that would be viewed as a general solicitation. And then,
Correct. Okay. Okay.
yeah.
Well, that makes sense. Okay. So we talked about the 506B. Tell us a little bit about the 506C.
Okay. So 506C. Again, investment of any size, unlimited number of investors. General solicitation and advertising are permitted. Okay.
Mm-hmm.
But there is a catch. Sales can only be made to accredited investors.
Right.
So if in the 506B offering, all the company had to do was to have a reasonable belief that this person is accredited investor. Reasonable belief essentially means that you give them a questionnaire and they check boxes, yes, saying
Right.
accredited, sign, and that's it. The company did not have to do any verification. Right?
You're pretty much self-certifying that you are an accredited investor.
I'm like, okay, fine, you say, and I believe you. So reasonable belief.
Right.
In 506C has the same reasonable belief, but also adds a requirement on the issuer to take reasonable steps to verify that this investor is in fact accredited. So if the company fails to do that for at least even like one single investor, the entire offering exemption is blown away out. That's it. You cannot use it anymore because you can only sell to accredited investors. One single non-accredited disqualifies the entire offering. So
Okay.
have to be very, very careful. And it's on the issuer, on the company raising funds to make sure that all investors are accredited.
And so what is the best way for folks to certify? Like, yeah, how do they verify that they are? What are the best steps for that?
Okay, so there are 3 ways essentially to do it.
Okay.
So the company can ask for, so first is like you verify on the basis of income. So the company can ask for investors' W-2s, right? Tax returns, 1099s, and kind of check them and say, okay, yes, this is a reasonable step.
Right.
Second one is on the basis of net worth. So here you have to ask for like bank statements, brokerage statements, I don't know, appraisal reports for any property, consumer reports for any debt. So it's more complicated to establish that the investor has the necessary amount of debt, of income, not income, but worth. Right.
Right.
And the third one is a written confirmation letter. You can get this certification or confirmation from a registered broker-dealer, a registered investment advisor, a CPA, or a licensed attorney. So, and this is really the easiest way to make sure that this investor is accredited. And this is what I see many companies do. So when they're raising funds, they just ask investors to send them their certifications that they are accredited. And the investors, they just obtain that there are actually online services. One of them is verifyinvestor.com. That's for about $60, I believe. I may be mistaken there, but for about that much can get you the certification letter. Obviously, you upload like whatever documents they ask for, and then they certify based on that. So right. I think that's kind of the easiest way.
I've used that as well, and it's simple. You just upload the documents, and they tell you yes or no. It's kind of the way it is, I guess. So that's the 506C. Pretty simple. You have to have only accredited investors. You cannot have any sophisticated investors. There is an unlimited number of accredited investors that you can have. You can solicit to them, advertise out there, as long as they are accredited. So that makes sense. Okay, and then you have to also make sure that you verify that they are in fact accredited. So, okay, so that's a 506C. 506B. I did want to ask this on the 506C side. 506B side. I'm sorry. We did, talk about it earlier, but this is for pre-existing relationships only, a 506B, right? So you have a pre-existing relationship with the sophisticated and with the accredited investors within the 506B offering. Okay.
Yeah.
So if, just to verify, if there is somebody else that one of those accredited investors that you have in your offering has a buddy that is also accredited and he wants to, be part of this offering, he cannot come in even though he is accredited. Is that correct?
Well, try to establish the pre-existing relationship as soon as possible.
But if it's already an ongoing offering, is he allowed to come in? I mean, it's a question that I get because we do have to have pre-existing relationship with them, but then again, they are accredited. So what's the, is it still, you have to be having a pre-existing relationship with them versus?
Well, it's the issuer or its agents that have to have this pre-existing relationship. So then the question is, can the investor who is already in, right, who can he or she be deemed to be an agent of the issuer with respect to establishing this pre-existing relationship with a new investor? It could be possible.
Okay, yeah, just wanted to ask that because I've had that question brought up a couple of times, and my understanding on it was, hey, if you have a pre-existing relationship with them, then they're golden. If not, then it's gonna be tough. It's gonna be a gray area, even though they are accredited. So that was my take on previous transactions and previous PPMs that I've been a part of. So okay, so. Do you have any other questions or any other input that you can provide for us that we haven't necessarily discussed?
Yes, maybe one thing.
Mm-hmm.
Try to make sure that you don't have any bad actors involved in your offering.
Okay, so what does that mean?
Okay, so let's say a company doesn't disregards the securities laws, right? Conducts an offering of securities, but without compliance with any securities laws or exemptions. And then the SEC starts to investigate and they issue an enforcement action and they issue, let's say, cease and desist order and so on. So the company may become a bad actor because of that. Bad actors are prevented from conducting future private placements. So, but it's not just a company that can become a bad actor. Directors, officers, and 20% stockholders or owners of the company, promoters can also be bad actors, maybe with respect to some past deals, right? So when you're putting together your syndication, make sure that none of the participants are bad actors, because this may disqualify your entire offering. Okay. So sometimes there are criminal convictions, there are SEC disciplinary orders, there are stop orders, injunctions, all that counts. There's a whole list of things that counts as and the list of covered persons is pretty broad. And this applies to both 506B and 506C offerings. Cannot have bad actors on your team. So find out about people you're kind of working with.
Yeah. So it's a good idea to have do a background check on the individuals that you're going to be working with to make sure that they haven't done anything shady in the past. So okay, well that makes a lot of sense. Okay, so you have definitely provided us with a lot of information on securities and the differences between a 506B, 506C. Among many other things. So I do have a question for you, Arina. And these are questions that I ask every guest every week, pretty much to hopefully help them out as well. So what is a good tool, source, or platform that you use almost every day that can also help others?
Or a platform, an online platform that I use. Well, I would probably say my calendar. I use Google Calendar, and every time I arrange for a call with someone or a meeting, I send an invite So it gets onto my calendar. I don't think I would probably like miss half of my meetings if they weren't in the calendar. It
Yeah.
makes it definitely easier to plan. So I would say that.
Yeah, definitely. The calendar, that's something that we use all the time as well, and it is very, very helpful. And so another question I have for you, Arina, is what is the biggest advice that you would give to somebody out there that is looking to do a PPM, maybe the first PPM, they haven't done it already, but, they're looking to do one and, they have an opportunity. And so what should they do? What is one big, piece of advice that you would give to them to make sure that everything goes smoothly and that they stay on the right side of the law?
Okay. Well, I think definitely get the right advisors. Find the right lawyers. Some lawyers compete on price, and I think it's not a healthy competition, because then they inevitably cut corners and deliver a work product that is not good. It's basically, if it's your PPM, your project's PPM, your name is on it, it's your reputation. Like, it has to be good. It should not be embarrassing in any way. And definitely conduct due diligence on the property or the investment opportunity. Know everything there is to know about it. Know the past, project the future, and just do a very careful, detailed analysis before jumping in. Don't be too excited about it, even if, no matter how amazing it sounds, there are always pros and cons, and you need to know that. And you need to describe both to your investors so they make kind of an informed decision. So they don't come back to you and say, well, you didn't tell us about that. Well, no, yes, you did. Look, page 56.
Yeah.
That's right.
Yeah.
So,
And one more thing I will add to that is to make sure that the people you're working with are also legit. You talked about the bad actors. So make sure that they're legit, and you do a background check even on them, even on your partners, because you never know as well, because they can bring you down. So yeah, Arina, you definitely have provided us with a bunch of value, and so I appreciate that. Where can my listeners go to reach out to you and contact you and see if they can also work with you?
well, we have a website. It's R as in Robert, S as in Sam, global.law, R as global.law. And my email is my first name, Arina, ARIN as in Nancy, at rsglobal.law. So email me, call me if you have any follow-up questions to today's presentation. I'll be happy to elaborate, maybe send you a link to the cases I mentioned. So just reach out.
Okay. Well then, Arina, thanks again, and I appreciate it, and I wish you continued success.
Okay, well, thank you so much. Good luck to all of you as well. Thank you.
Thank you, Arina.